representing, in effect, the Trump administration. John Sauer is right now with Clarence Thomas, the Supreme Court Justice. They're going back and forth. Let's listen to it.
Temporary sojourning multiple places in the congressional debates, and all of those quotes go in our direction.
And there was Justice Sotomayor brought up Wong King Ark. There was no question in that case that about domicile, was there?
I disagree. The court says at the very beginning of its opinion, here are the accepted facts. These are lawfully domiciled here. When it states the question presented, it talks about domicile. When it recites the legal principle at page 693, it says domicile 3 times. And at page 705, at the end of the opinion, it says, here's the single question we've decided. We've decided that Chinese immigrants with a permanent domicile and residence here are fall within the rule of birthright citizenship.
Justice Alito? Under the minimum definition of domicile, which I think existed in 1868 and continues to exist today, a person's domicile is the place where he or she intends to make a permanent home. Now, normally, you would think that a person who is subject to arrest at any time and removal could not establish a domicile. But we have an unusual situation here because our immigration laws have been ineffectively and in some instances unenthusiastically enforced by federal officials. So there are people who are subject to removal at any time if they are apprehended and they go through the proper procedures. But they have, in their minds, made a permanent home here and have established roots. And that raises a humanitarian problem. And I wonder if you could address that.
If I make one legal and one humanitarian, the legal point is if you look at those cases, for example, Park Carson against Reed, Park against Barr, this court's decisions in Elkins and Toll against Marino, they talk about the legal capacity to create a domicile, excluding someone who may have the subjective intent, which otherwise would be determinative, as being excluded. On the humanitarian point, I would point out, as I said at the beginning, Justice Alito, that the United States rule of nearly unrestricted birthright citizenship is an outlier among modern nations. It's a very small minority of nations that have that rule. For example, every nation in Europe has a different rule, and the notion that they have a huge humanitarian crisis as a result of not having unrestricted birthright citizenship, I don't think is a strong argument. And I point out, obviously, for reliance-related reasons, this executive order applies only prospectively, and we ask the court to rule only prospectively.
Justice Sotomayor?
I agree with you what the European nation's rule is, but England was always different, wasn't it?
Not until 1983 it changed.
That's not quite true. The Wong Kim Ark does a wonderful job of laying out the English rule. And you claim it was different, but there isn't any treatises or scholars who say it's different. English rule was always by birth. Other countries were not by birth. Let me just go to the implications of what you're asking us to do. You are asking us to overrule Wong Kim Ark? Well, Wong Kim Ark's parents were domiciled in the U.S., but they owed loyalty to China. They eventually returned to China. So they didn't have a primary allegiance to the United States. So you're not asking that. Are you asking us to overrule then our cases, one of which said that a child of illegal aliens was a citizen? You're asking us to overrule that.
No, first of all, we're not asking you to overrule Wong Kim Ark. We agree with the holding of Wong Kim Ark and much of the reasoning. And then as for those later cases starting in 1966, where the court makes sort of, unreasoned references to...
Wait a minute, Finn Talculus, the respondent unlawfully overstayed her visa and gave birth to a child here. The court, Harlan II, wrote, the child is, of course, an American citizen. That person wasn't domiciled here lawfully. So you're asking us to overrule that
I
case?
wouldn't say we're asking you to overrule. We think that's similar to a drive-by jurisdictional ruling where there's a simple statement that's not debated. There's no further analysis of it. There's really an assumption there. And we think that's similar to cases the court just assumes jurisdiction without discussing.
When we ruled in Trin that Indians could not become citizens, the government then after began to unnaturalize many Indians who had been sworn in as citizens. You asked us to concentrate only on the prospective nature of the citizens' order. But the logic of your position, if accepted, is that this president or the next president or a Congress or someone else could decide that it shouldn't be prospective. There would be nothing limiting that, according to your theory.
If, as we asked, the court confines its ruling to prospective relief only, which it did in
No, I'm
such
saying to you, that's what you're asking us for relief right now. I'm asking whether the logic of your theory would permit what happened after the court's decision in Trin, that the government could move to unnaturalize people who were born here of illegal residents.
No, we believe the court should do what it did in Sessions against Morales-Santana, where there was a ruling that would have deprived people who are already citizens of citizenship, and the court said this applies prospectively only, and we think that's the appropriate course here.
But that's not what we did in Trin.
We think that the Sessions provides the proper course here, and that's what we're asking. We are not asking for any retroactive relief.
Justice Kagan?
General, I think even your brief concedes that the position you're taking now is a revisionist one with respect to a substantial part of our history. And I think that that's in large part because of Wong Kim Ark and the way people have read that case, which of course was in the late 19th century, and have read it ever since then. And what that case suggests is, there's a very clear rationale. You say, it says the word domicile a bunch of times, which it does. It's a long opinion. It says a lot of things. But the rationale of the case is really quite clear. It says there was this common law tradition. It came from England. We know what it was. Everybody got citizenship by birth, except for a few discrete categories, which were the ones that the Chief Justice mentioned at the beginning. And that tradition carried over to the United States, and then what the 14th Amendment did was accept that tradition and not attempt to place any limitations on it. And so that was the clear rationale, a clear rationale that is diametrically different from your rationale. And everybody took Wong Kim Ark to say that, and to say that as a result of that, of course, birthright citizenship was the rule, and I think everybody has believed that for long time. And I guess my question is this. You have a story about the reasons why we should go back to what you view as the original meaning. And given the long history of this country's understanding about birthright citizenship, what would it take, what do you think it should take to accept that story in terms of the magnitude of the evidence that we would need to see in order to accept this revisionist theory and in order to change what I think people have thought the rule was for more than a century?
Let me make 2 points in response to that, one historical and one legal. Historical point, I disagree with the way you've characterized the understanding of Wong Kim Ark, and I would point to something that's emphasized in their amici's briefs, which is in 1921, Richard Flournoy, who becomes a senior State Department official in the Roosevelt administration and pushes their theory as to temporary sojourners, writes a law review article in 1921 where he says, I think that children of temporary visitors should be citizens. But he admits that is not the understanding of Wong Kim Ark. He admits Wong Kim Ark did not hold that. And he admits that there's an array of authorities that go against him. He talks about careful and reliable, high authorities. And that's referring to the consensus that we point out in pages 26, 28 of our brief. We've got 12 treatises from 1881 to 1922 that all say, including for decades after Wong Kim Ark, that say children of temporary sojourners are not included. What happens between 1921 and the 1930s? Well, Mr. Flournoy became a senior State Department official. He adopted that as the policy of the Roosevelt administration. So their argument is basically saying there wasn't this consensus going back to 1898. The consensus, as their own author admits, goes entirely in the opposite direction. For 50 years, right? For 50 years, from the framing of the clause through the 1920s, maybe 60 years, the general understanding when it comes to what's at issue here and was not an issue in Wonka Mark is that children of temporary visitors do not become citizens under the clause. And then the legal point, you referred to this sort of concept of temporary local allegiance, and they rely on the Schooner Exchange, this theory that you've got temporary local allegiance. But if you actually look at page 572 of the Congressional Record, right at the beginning, introducing the Civil Rights Act, Senator Trumbull says, I said not subject to any foreign power. I wanted to say born in the United States and owing allegiance to the United States, but I was aware that there's a quote, a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So Senator Trumbull says the reason I haven't adopted the language and meaning that they say should be packed into these provisions is that everybody knows that the children of temporary visitors should not be citizens.
Thank you, General.
Justice Gorsuch?
Just to follow up on that point, General, one interesting counterpoint about the understanding of Wonka Mark that followed with respect to temporary sojourners. And I take you've got your well taken points. But there was, of course, John Marshall Harlan, the great dissenter who dissented in Wonka Mark and later gave a bunch of lectures. And he posed the question about the sojourners. But suppose an English father and mother went down to the hot springs to get rid of the gout. And while there, they have a child, now back in England. Is that child a citizen of the United States, born of the jurisdiction thereof by mere accident of birth? And he says, under Wonka Mark, he is. And he continues, I was one of the minority. And of course I was wrong. Now, I'm sure that was tongue-in-cheek, but what do you do with that?
I'd say two things in response to that. First of all, he gave a speech, but we have 12 uncontradicted treatises that say the opposite, that is not what Wonka Mark means, and that's not the meaning of the clause. But also, I make a more fundamental point. When you're looking at Wonka Mark, one of the dissent has this dominant theme that really dominant theme like you can't be doing this because you can't make and we all agree, or it's obvious that the children of temporary visitors do not become citizens. And how does the majority opinion address that? It says domicile 3 times when it recites the legal rule. It says permanent residence and domicile when it decides to hold it. So the court should be bound by what it says. This is what we're deciding. Again, on page 75, it says this is the single question. Now, there's been a lot of discussion up to that point, but at the very end, they said the single question we decided is the citizenship says the children of Chinese immigrants with a permanent residence and domicile in the United States.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously, they granted citizenship by statute.
Put aside the statute. Do you think they're birthright citizens?
No, I think the clear understanding that everybody agrees in the congressional debates is that the children of tribal Indians are not birthright
I
citizens.
understand that's what they said, but your test is the domicile of the parents, and that would be the test you have us apply today, right?
Yes. So a tribal Indian, for example, gives up allegiance to.
Born today, birthright citizens.
I think so on our test. If they're lawfully domiciled here.
Okay. And then
Not sure. I have to think that through, but that's my reaction.
I'll take the yes. That's all right. And then I just want to ask you quickly about the INA, adopted in 1940 and 1952. It uses the same term as the citizenship clause, and one might have a pretty good argument. I'm sure you got some arguments along just these lines that it should be understood to mean whatever it meant in 1868. But there was a lot of water over the dam between those two things. And as your brief points out, the Roosevelt administration, there's a pretty strong jus soli move. That is to say that the thin concept of jurisdiction, power over, is enough, a broader understanding of birthright. Would there be an argument for reading that statute under its original plain meaning at the time, 1940, 1952, to perhaps have a different meaning than the Constitution?
We don't think that's the best interpretation for 2 reasons. One is it would be very surprising if a statute that says exactly the constitutional phrase subject to the jurisdiction thereof were interpreted to mean something totally different or to ossify a then current misunderstanding of the clause. We think that the best analogy here is probably state long-arm statutes. Take a sort of non-controversial example. State long-arm statutes routinely say we're going to exercise personal jurisdiction to the extent of due process. It takes the constitutional standard and it puts it in the statute. And nobody thinks that those ossify, are limited to the precedent, this court's precedents at the time they were enacted. Everyone thinks that that phrase, due process, incorporates, the developing law of due process in minimum context and so forth, including from this court. So we think that's the best analogy when you're looking at the constitutional phrase itself. When you take it out of a freighted context, the natural interpretation is say this means, this reflects the objective meaning of the Constitution. And the objective meaning of the Constitution is its original public meaning in 1866.
Do you see notable counterpoints to that argument?
I'm sure there are arguments on the other side. We addressed them in a brief.
So really, at the end of the day, then, this is a straight-up constitutional ruling you want from this court, winner, lose, or call.
Yeah, we think that the statute of the Constitution means the same thing. If the court disagrees, obviously we prefer an adverse ruling. The court's going to do that on a statutory basis and a constitutional basis.
You're just disavowed that in responses to it by saying that it's not an available option.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now, we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just
Thank you.
Justice Kavanaugh?
General, how should we think about the text of the 14th Amendment subject to the jurisdiction thereof as distinct from the different language of the Civil Rights Act of 1866, which refers, as you know, to persons not subject to any foreign power? Those texts are, on their face, different, and the history that Justice Kagan referred to might have developed quite a bit differently if the 14th Amendment's text had used the phrase that was in the Civil Rights Act.
That's an excellent point. And this court has held in multiple cases, including against Hodge and general building contractors, has recognized that they were intended and they did mean the same thing. And that's powerfully reinforced by the congressional debates where what they're discussing is they said they were dissatisfied with the language of the Civil Rights Act because the phrase even is not text. They thought it was ambiguous. And so they switched to the affirmative statement as opposed to the negative statement. The affirmative statement is to the jurisdiction thereof, but there's express statements in the congressional record essentially that we're doing the same thing, and that is what this case law has reflected.
Why did they say the same thing?
Again, it appears they prefer these sort of positive formulations, so the jurisdiction thereof, as opposed to not subject to any foreign power. And again, there's a deep